Got it. Thank you. Yeah, I was getting noise before. That's all I was checking. Thank you.
Test, test, test.
Know where it is? Right down here?
Yeah, I'll find it.
Okay.
Here
Can
now.
I hear you on the microphone?
Yes, please.
Go ahead.
Test, test, test.
Okay.
Testing.
Good. Thank you.
Thank you, sir.
Appreciate it.
So then what? I'm gonna turn off the sound right now.
I'm sorry?
I'm gonna turn off the mics.
Okay. You turn them off now?
And then when they start, they turn them off.
Okay.
So this is the position, you know. See this? This is the main switch.
Absolute mess.
It's over here.
Been really bad. Oh, well, it always is.
Okay.
I mean, I expect it to be bad, but
Okay, welcome to the Public Service Commission's rulemaking 91 on transmission issues. And I guess we're going to start with a presentation from staff, correct?
Good morning, Chairman, or Chair Commissioners, Michael Dean on behalf of staff. I also have Samri Derrier here with me. We're here regarding rulemaking RM 91. And this rulemaking was initiated in case number 9669 by order number 90684, which requested staff to review the definition of modification of a transmission line at Comar 20.79.01.02 B28. And staff spent some time working on this, and we decided to see if we couldn't change the definition of modification of transmission line such that reconductoring of transmission lines would become easier. And I'll just start going through the changes suggested by staff. And first of all, staff noticed that the regulation was kind of mixed up because it had parts of generating station modification and transmission line modification. So we reordered the beginning of it so that the section on generating station came first, and then the section on transmission lines was second. And so that's not really a change, that was just a reordering. And the sections that staff added are in Part D of the definition. And I'll just, we went over some recent CPCN exemption requests that had been granted, and looked for common items in there, and decided to include those in the part of modification of items that the definition would not include. The first one was essentially the finding from the order, and that's that the building of any part of an existing transmission line consistent with the design as described in a application of an approved certificate of public convenience and necessity would not be a modification. So that's just basically following what's been already approved. The second one was the replacement of a transmission structure with a structure of a different type if the height of the replacement structure did not exceed adjacent structures in the transmission line. And that's been a common change in CPCN exemption requests. The third one, a replacement of a transmission structure with a higher or larger structure if the increase in height is required to comply with current design standards. And that is also something that the Commission has routinely, well, I won't say routinely, has approved in its evaluation of CPCN exemption requests for transmission lines. The fourth item has come up a few times where during rebuilds of a section of a transmission line, the base or foundation has been increased in size. And because the definition of a modification includes requiring higher or larger structures as not being permitted if there's an increase in voltage. The issue of whether an increase in the base or foundation was included in that, and the commission has, when this has been brought to their attention, has always ruled that the increase in size of the base and foundation is not a change. That's considered a modification within the meaning of the statute. The fifth item that staff added was adding an additional transmission structure to facilitate the interconnection of a substation, switchyard, and we added other facilities if the new structures do not exceed the height of adjacent structures in the transmission line. And that has also, in several occasions, been approved by the Commission in CPCN exemption requests. 6 was a suggestion by staff. However, we did find one case where this was actually approved in a CPCN exemption request. The use or replacement, the use of a larger replacement conductor to increase capacity if the increase in the diameter of the conductor does not exceed 15% and the voltage of the line is not increased. So that would be consistent with the current definition of not increasing voltage, and it would also allow the use of advanced conductors or just conductors with higher capacity. In that prior case, that's where the 15% was being used in that case. And the last item was routine maintenance or repairs. The definition of modification to generating station has exclusions, and this is one of the exclusions from that. And we listed this when the CPCN exemptions were added to the statute at 7-207. This was initially an issue, and we thought we'd put it here to so that it comes up mainly during repairs. After staff filed these comments, the Potomac Edison, the Exelon Utilities, PPRP, and the Office of People's Counsel filed comments. And looking at the comments, there were several suggestions from BGE that we thought were worthy of consideration. And the changes from of BGE staff had included a change in the rated operating voltage of the transmission line as being one of the considerations under paragraph C, and both Potomac Edison and the Exelon Utilities pointed out difficulties and inconsistencies if this was added. And staff, after reviewing the issue, agrees that this change should be included. Going to Part D,
Excuse me, Mr. Dean. I just had a couple clarification question, just two of them. First off, in the document we're looking at here, we have two different colors there, red and blue. Staff's is the blue? Yeah, okay.
yes, staff's additions were blue and edits by BGE are in red.
Right. Okay, so the utilities are red. Okay, so because we got a handout here and it's black and white, so I couldn't. So I was just trying to make sure I knew what we were talking about. Okay. Yeah, and I have it up here. So, all right. Thank you. Thank you, Mr. Chairman.
And in addition, they have the lines at the side. Going to D2, BGE grouped some of the changes that staff was recommending. And they've also added an increase in size does not exceed 25%. An increase in structure size does not exceed 25%. They explain their reasoning in their filing. Staff doesn't object to it, but this may be reviewed on a case-by-case basis by the Commission when CPCN exemption requests are filed. By listing these changes, we're not saying that these would be automatically excluded. Each CPCN exemption request would have to provide its own basis for granting an exemption, but by having these in the regulations, it would be something they could cite and perhaps make the CPCN exemption requests more uniform. Part 3, BGE, again, is grouping these together and added an increase in size does not exceed 25%. Going down to 5, the adding a new structure to interconnect a substation and other facilities. They have again added the lines discussing whether an increase in height is required to meet utility design standards or practices. An increase in height of the structures does not exceed 25%. And I believe they're referring to adjacent structures there. For Part 6, increasing the size of replacement conductors to increase capacity. We had 15% as the increase based upon the prior instance that we found. The Exelon utilities are suggesting that this be increased to 25%. And of the factors for approving a CPCN, the size of the conductors is an aesthetic factor. So in increasing the size, you're affecting the aesthetics or the view shed by increasing the size of the conductors, and it's whether or not it would be really noticeable if you had an increase of 15% or 25%. We initially had in our drafts 25%, but we went down to 15 when we found that example of a prior approval. So staff doesn't object to this change to 25%, and it would allow the use again of advanced conductors and increasing the ability of companies to reconductor lines using exemption requests. There have been a few exemption requests involving reconductoring where the companies have been very careful not to increase the size of the conductor, and that may have limited their options. And the last recommendation that the Exelon utilities made that we agree with is the replacement or upgrade of shield wires. And by upgrade, that would include adding shield wires where none existed previously, and they're not as noticeable as the conductors themselves, so staff did not have an objection to this change. And with that, we're here for any questions.
Okay. Commissioner Fleischman.
Morning, Mr. Dean. Your efforts are because of a commission order that was issued before my time, just a little before my time. And what is your sense of what your responsibilities were in complying with that directive?
The order itself seemed to suggest that because the definition of transmission line hadn't been reviewed before the commission in a while, that it was perhaps time to review it. There is no direction other than that that we took from the order. It didn't say one way or another what we should be doing in our review.
Okay, but what was your sense? I mean, defining transmission line, I don't know that was really what the commission was asking you to do, or at least that's not how I read it. So I guess my question is sort of what sort of triggered their request to you? I mean, was it that there are new technologies and there are new opportunities for enhancing the grid, and the commission wanted you to think about how to incorporate these technologies within the scope of COMAR? Is that kind of what?
Well, that's what we did, but I don't believe that's what the commission had in mind. What happened was there was an appeal of a proposed order, and part of the appeal dealt with section 7-209 of the Public Utilities article, which states that the commission should examine alternatives to the construction of new transmission lines. And it gave several things to consider. The CPCN case involved the rebuilding of an existing line. So the company Potomac Edison, following the text of the statute, did not consider the need to evaluate new routes or new technologies to replace the existing transmission line, which is a 500 kV line. And as a part of the proposed order and also the commission's order, they looked at the definition of transmission line modification, which of course would involve an existing line and not a new line. And I think it was simply because they were looking at this definition and which basically was limiting the definition to not excluding or as excluding obtaining real property or additional rights of way, or constructing larger or higher structures to accommodate increased voltage or larger conductors. And I can't say exactly why the commission requested a review of the definition, but it may have just been because they found it not providing much guidance in this case.
Okay, and so what you've done is you've changed the definition so that you believe it provides more guidance.
Yes, specifically the rebuilding of an existing transmission line, which was the issue in the case. We added that as the first item of the new Part D.
Okay, and so your definition would then exempt those entities from having to get a CPCN. They would get an automatic waiver.
Well, they would have to request a waiver and show that they complied with the requirements of.
But as long as they complied with the requirements, then they would receive the waiver.
Yes, and the commission has had a few cases where rebuilding of a transmission line was requested and approved as a waiver.
Okay. So going back to the statute, so I'm looking at 7207. Is there any reference to modifications?
No, but when we did review Part E2, which lists the criteria that you would consider. And with that, we looked at whether a change would affect the aesthetics as being a criteria to consider. So we looked at, we tried to include changes that would not be significant changes to the how a transmission line's impact on.
Okay, but I'm just talking about just the PUA. As written, there's no reference to modification, correct?
That's correct.
Okay.
Although modification would fall under the definition of construction in general.
Oh, okay.
So that's why.
Okay, but that's also not contained within COMAR. COMAR actually defines modification, and they define modification as covering literally what's in the PUA now. So it'd be either you get a waiver if you don't obtain new property or rights of way, or you don't require larger or higher structures to accommodate increased voltage or large conductors. So it literally just lifted that language and put it in Comar, correct?
Yes.
Okay. Is there any language within the PUA that gives any kind of discretion on how this language is to apply? So, for example, does it have some wiggle room for the commission to allow for waivers if there is a little bit of increase of voltage or a little larger conductor?
Well, first of all, the portion of larger conductors that's in our proposed change doesn't include increases in or in the structure. It's just if you're increasing the size. So we're not trying to change the requirement that's already there.
So the structures would remain the same,
Yes,
and to accommodate, so it wouldn't require larger or higher structures.
but it would just be a change in the conductor size.
Okay, so I'm reading the additional language that the utility is proposing. Any increase in the height of the replacement structure is necessary to meet current industry or utility design standards or practices, or any increase in height of the replacement structure does not exceed 25%. I read that as structure.
Yes.
Okay, so can you show me in the PUA where there's wiggle room in the waiver provision that allows for us to approve a waiver if there's an increase so that the structure can be higher than what is currently in place?
Well, the commission, in considering,
No, I'm literally asking you
I-
if there's any wiggle room in the PUA.
not directly, although the section on granting waivers to the CPCN requirement at,
Right, that's a different place. I'm talking about, I mean, you want to make a change to the, I can tell you frankly that the modification language to me is incredibly confusing. I look at the statute. I mean, the statute is not crystal clear, but it's pretty clear, and it allows for a mandatory waiver and a discretionary waiver. It doesn't talk about modifications. The shall, because I look at the commission shall waive, doesn't give us any discretion. We've already had this conversation with P several times about the language, because this is a mandate on us to waive if certain conditions are met. It doesn't seem to give a lot of discretion. It's pretty clear on what it's required, and then it gives us more general authority to waive for good cause. But that's not what we're. If you mix them up, then it becomes that much more confusing. So I'm taking your modification language to be a mandate on us, that if it meets those modification criteria, we have to waive. Is that correct? I mean, and I can. That's how I read it, but I can tell you that because you're not able to answer me right away, and I'm a little confused. I think all this does is it just makes the use of the term modification that much more confusing. So all I can tell you is I'm looking at the PUA, and as far as I'm concerned, the PUA is what we have to follow. And the PUA gives us no discretion on making bigger towers or increased voltage. And I can tell you one other thing, and this is the concern I have with this mandatory waiver provision, is that the industry is changing. and technologies are out there that can improve the function of the grid, and that's why we want to see alternatives. We want them filed so that we can see if there are better alternatives that are going to put less of a burden on ratepayers. But the more you put the actions that the utilities are taking in a category of mandatory waivers, it's less on us to be able to actually look at what they're proposing. I mean, the utilities, and this is I'm not casting aspersions on them, but they have a motivations that's different than our motivation. Their motivation is to build and earn a return. And I'm not saying that that's a wrong thing, but they may not necessarily in choosing a way to address grid constraints, they're going to choose the path that gives that is beneficial to them. It could also be beneficial to ratepayers, but it's our responsibility to look to see what is the most beneficial. And the more you put the actions that the utilities are taking in a category of things we can't look at, and we lose our ability to look at alternatives, I think that's hurting repairs. And I'm not really seeing that there's a huge value in that. I wanted to ask this your first condition, the rebuilding of all or any portion of an existing transmission line consistent with the design as described in the application of an improved CPCN. What if there had been no CPCN? What if the line is so old that there is no design?
Well, the reason we put the part about an approved certificate of public convenience and necessity was to not allow automatic waiver for rebuilding of an old construction, because in many cases that's going to require upgrades to the current design standards. So we didn't.
Okay, so you don't. So this is again, this is the confusion. I feel like I'm like walking around in circles. Okay, so if something doesn't qualify as a modification, then it is subject to a CPCN.
Well, a CPCN or a CPCN waiver, depending on the changes that are being made.
So for number one, is that going to be is the rebuilding that is consistent with a design that's already on file? Is that an automatic waiver?
That's close to essentially doing maintenance if you're rebuilding the line.
Okay, what if there's no design? Or, and I think this is more importantly, what if there are better ways of replacing the line? I mean, when does it stop being O&M and it's like sort of an absolute rebuild? Or what if there's a better, more efficient way of doing it, but it's not part of the design? So you're going to allow for a waiver for a rebuild of an existing design, even if the design ends up being, 50, 60 years old and doesn't reflect current technology.
Well, for changed design standards, the company would have to follow the current design standards in rebuilding. And I would assume that most companies would want to, when they rebuild the line, they would want to rebuild it as best as they can right now.
But I'm reading this, so again, I'm not really this list of criteria. I'm not really sort of understanding what gets an automatic waiver, what doesn't. But so under this change of modification, so modification does not include the rebuilding of any portion consistent with the design. Is that supposed to get an automatic waiver then?
That was the intent.
Right, and if that's the intent, I think that's a bad idea, because either if you don't have a design or you have a very old design, do you really want to build it the way it was built 60 or 70 years ago? But also, if you have a better way of doing it, if you have a more efficient way of doing it, if you have a less costly way of doing it, then why should we allow for a waiver if it's consistent with an old design, but then require CPCN if there's a better mousetrap out there? I'm not really understanding why we would allow a waiver there.
Well, the wording that I put here as a suggested change is basically the holding from the order of the commission from that case. If that's wrong, then it's wrong.
Well, I'm assuming, I'm not sure what case you're talking about, but the fact that we looked at the specifics of a case and we were able to consider different factors is kind of what I'm getting to. I mean, what this is doing is it's taking away our authority. And I mean, I don't think this is at all consistent with PUA, so I think that's a big problem. I don't think there's a lot of discretion in the no discretion. I mean, I think that it's pretty clear about when you get a waiver and when you don't. But what seems to be happening is there then is all these other ways in which the utility can avoid having to come to us for and offer alternatives because there's just a larger box of ways in which they can avoid our jurisdiction. I'm not really understanding why there's a good result there. And I can tell you the other thing that I'm most concerned about is that my understanding is that there was not a lot of engagement with the rest of the industry when you put together this proposal. Because my guess is that it wouldn't look like this if you had engaged with others.
Well, for your earlier statement, this wasn't intended to not require the electric companies from coming before the commission and requesting a waiver for the work that they were planning on doing.
But they don't request it. They tell us that they're entitled to it. And then we don't have a choice but giving. I mean, it's nice that they come to us, but it's not, we don't have discretion. And that's what I've been told several times, is that it doesn't really matter what my concerns are with the proposal. I have to approve the waiver. The fact that they come to us doesn't give me any comfort. And all this is doing is it's just taking away more of our authority and more of our ability to look at the proposals at the very moment where this is becoming a huge issue for us and a huge issue for ratepayers. I mean, rates are going up, and the last thing we want to do is not be able to look at the specifics and be able to tell the utilities, we want to see alternatives, and alternatives that are cheaper. I mean, what you're doing here is you're taking away our ability to do our work, and that's really troubling. Mr. Chairman, that's all I have.
Okay. Commissioner Linton.
Thank you, Mr. Chairman. Good morning. So I want to pick up a little bit off of Commissioner Suchman's last point, and just a couple of, I guess I'll call them housekeeping questions to make sure we're all on the same page. The filing that you have posted up here currently, that is the reflection of the Exelon Joint Utilities filing.
That's correct.
So you didn't. I know that they have staff's filing, and they just wrote on top of it. So I guess my question is, has staff adopted the Exelon Joint Utilities proposal, or are you not adopting all of their changes?
We've suggested that their changes would be, yes, I guess is the answer, although the general increase in height of replacement structures up to 25%, that was not part of staff's original filing. And of all the changes they're suggesting as being a part of the definition, that's the one we have had the most discussion about.
Okay, so, well, I can see it there. It's in the, but that appears a couple of times in here. So, with the exception of the 25% reference, that's throughout the, I'm just going to call it the joint utilities file. That one, everything else the staff has adopted as you've accepted, or I guess I've endorsed as your position.
I would say yes.
Okay. Okay. So we also saw some, I know we can hear from them later. Potomac Edison made a filing and they produced just one or two changes. They didn't have a draft like this. But both the state agencies, DNR, PPRP, and OPC, all requested an opportunity to review these further, which would include, and I thought it was a bit surprising, included proposing a work group, which, you know, some parties are not as interested in having as others are, but they actually recommended that for this. What's staff's position on that?
Well, well, first of all, if the commission is not looking for any changes in the definition, we shouldn't have a work group, because you know, that would be a waste of time in that case. However, if the commission is looking for changes to the definition as requested in the earlier order, staff would not be opposed to a work group to discuss this further.
Okay.
But if we're going to have a work group, it would be helpful if the commission gave some sort of guidance as to the types of changes that would be that the commission would consider as being appropriate.
Okay. So is it, and I know Commissioner Sushman alluded to this earlier, is it fair to say that the staff drafted this version of the regulations without consulting with the other parties?
Our initial draft, that's correct.
Okay, so the one filed with the commission that initiated the RM91, that the commission said, you know, this is notice initiating rulemaking. Here's the draft that everybody should comment on. That version, that was the one that the staff proposed, and you drafted it without consulting the other parties.
We did have one virtual meeting where this was shown to various parties.
Okay.
And the initial response was, well, one of the responses, I'll put it that way, was how come staff didn't just say no changes in response to the commission's direction to look at the regulation.
Okay, so it's fair to say that there were differences of opinion,
well,
among all the parties.
True.
Yeah.
True.
Okay. All right. Process-wise, nothing that the staff has done is outside of the requirements of the Administrative Procedure Act. So I'll just say that up front. That's not the issue at all. But I would like to ask one additional question about the 25%, because I actually had a question about that for the utilities, but since that's not something that staff has adopted as part of its position here today, what is staff's concern with the 25% suggestion?
Well, if you're looking out at a transmission line and they're going to do work on it such that structures are going to be increased in height by 25%, that would definitely be a change that affects the aesthetics as noted by the any resident in the area. So that's the only reason that's problematic.
Okay. So is there some, and I'll just use it's not a legal term, but is there some magic behind the number 25% as opposed to something larger or smaller? Or do we know that that's a number where people start to notice the difference?
I'm not sure if there's a number or not. There's been times when the commission has accepted changes in height for other reasons, such as meeting current standards for separation and things like that. But just a blanket statement of 25% being okay. We took that as being, a concern.
Okay. So I'll wind back the clock a little bit. I can recall when some of the mandatory waiver filings first started here at the commission. Thankfully, I don't have to wind the clock back too far, but I do recall when they started, and there was some concern at the time. One of the joint utilities did note in their comments some concern about the length of time for a CPCN filing, and suggesting that it was lack of a better word, more preferred to not have to go through that process because of the different benefits that the joint utilities argued would accrue to the consumer, to themselves, and everybody else. From the staff perspective, I'm curious about what your experience has been with the number of utility, and this is for any of the companies, not just the joint utilities, but the number of utility CPCN filings that have been made for transmission lines. And we can go back, I know you don't have a specific number, I'm not going to ask you for that, but I'm wondering if there's been some avoidance of additional and new transmission line projects because of the concern that there's been delays, or basically the process for going through a full CPCN is so extensive. Have you noticed that at all, or have you just?
Good morning, Commissioner Linton. So I can't really say that didn't have that I guess perception. We did have significant transmission CPCN waiver requests, but I'd have to go back and see what the trends are. I think a lot of the transmission CPCNs that I recall were to add a structure somewhere to that effect. Nothing significant, but I might be wrong. I would have to go back and take a look at the database and get back to you on it.
Okay. Well,
if I could add, it's possible that increases in conductor size have been avoided as a possible upgrade to the distribution line.
okay. Right. Yeah, that certainly could be the reason why you don't need new CPCN projects, because you've made improvements to existing lines, and as a result, you don't need to have other projects. but as Commissioner Sushman did allude to the fact that we do have a lot of need for additional distribution in the state. We have lots of new generation popping up in different places that are not connected to the grid as it normally existed even 10, 15 years ago. So that just by itself suggests that we may need new transmission lines to connect existing a new generation to the grid, and not just the transmission but the distribution lines to support that new generation. So I just wanted to make sure that we didn't have processes at the commission, either in our regulations or even in the PUA, that is discouraging our utility companies from moving forward with those types of projects, because from their perspective, the CPCN process is administratively burdensome. And so the end result is that we don't get the distribution lines, we don't get the transmission lines, we build the generation, maybe, but we have a difficult time interconnecting it. So that's kind of the end result of what I was concerned about. And and I know that was one of the issues we were thinking about. It probably didn't make its way into the orders in 9669, but that was one of the concerns we were thinking about back then, when we started getting all of these mandatory waiver requests, and we were just rebuilding the same lines we already had. And certainly there's benefits, as you already mentioned, with new technology and sizing and the like, but if there's need to do something additional, we don't want our utility companies to say, well, we have a choice between rebuilding a line that's already there, and we can start in a year, versus going through the CPCN process and it takes 4 or 5 years. We'll just go for the one that we can start in a year. And so we want to make sure that that's not a limitation for getting new generation on the grid and all of the support around it. So that was my concern, and I just wanted to make sure that you hadn't noticed a trend of filings happening only for mandatory waivers as opposed to, and I won't, I mean, it could very well be the case that these projects are necessary, but that we're not seeing the utility companies make a choice towards mandatory waiver projects as opposed to full CPCN projects.
In response to your expressed concern, I don't think the utility companies would discuss that with staff directly.
Right. No, I don't think they would, but I mean, we can tell from the filings.
And, perhaps the utility companies could, discuss that further.
Well, I plan on asking them too, but they got the benefit of the question in advance now. So, thank you, Mr. Chairman. That's all I had. Thank you for answering my questions.
Okay, Commissioner McLean.
Good morning. With 9669, under the staff's proposed revised definition of modification, would that case just be eligible for a mandatory waiver now, in your mind?
There might be certain design aspects of the project that would have required a CPCN still.
Okay, all right. Because you indicated, I believe you indicated that the mandatory waivers were more for like maintenance-related issues. Is that correct?
Generally, yes.
Something that has to happen quicker rather than going through the full CPCN.
Well, there's some of the suggested changes are related to interconnecting new generation or adding substations. Those types of items routinely come before the commission as CPCN waiver requests for evaluation.
Okay. Would it be a fair reading of, I know 9669 maybe wasn't as clear as staff would have liked it, but it seemed to me in reading it that the commission's concern was that there was no ability or requirement on the part of the utilities to consider alternatives to just rebuilding it, as Commissioner Sussman had indicated. Is that a fair interpretation?
I would say that I did not get that from the order itself. That was the concern in the Office of People's Counsel appeal of the order. And that was not a clear statement that we got from that order.
Fair enough. Is it, assuming that the commission's intent was that such projects should be, utilities should be required to file alternatives in like a rebuild like that, would it just be simpler to have a statutory change to the extent that a statutory change can be simple?
Well, in a recent case in the commission's delegation order to the public utility law judges, it included statements that alternatives were to be evaluated. That this was a CPCN for a rebuilding of the line.
Okay. All right, thank you.
Okay, so getting to this 25% number, you had said earlier that staff had a different number, but agreed with 25% as suggested by the Exelon utility. So can you tell me what it is that they told you that, convinced you that 25% was the right number?
Are you referring to this conductor size increase?
Well, I noticed in all of their changes, they reference 25%. So obviously 25% means something to them. And so I'm just trying to figure out why they think 25% is the right number, and I'll ask them when they get up here. But I also want to know from you what they told you as to why 25% is the right number.
Well, 25% for the conductor increase over our suggested 15%. That they stated that 25% would include all changes in that they thought would be 25% would not limit the changes in conductor size for improvements either as for advanced conductors or just simply larger conductors for increased capacity.
Okay. Because I guess my concern is that, if we adopt this in the regulations, well, it's not exactly like a statute, it's pretty permanent. And since, changing regulations is not an easy process, I want to make sure that we get the right number. So
Yeah, staff originally, as I stated, had considered a larger number than 15, but we went down to 15 simply because we found the previous example. Generally, we would want to support the ability to reconductor transmission lines as needed. That's really the lowest cost alternative for upgrading the grid in general.
Okay. All right, thanks. So why don't we turn now to hear comments from some of the other entities. Let me start with OPC and PPRP. Actually, if you want to,
At the table.
yeah, make it easier so you don't have to stand up the whole time. So.
Do you want to start? All right, I'll start. Good morning, Chair and Commissioners. Brock Miller on behalf of the Office of People's Counsel. As stated in our comments, OPC recommends that the Commission not publish staff's proposed COMA revisions. In staff's filings, staff stated that these proposed revisions are meant to provide clarity about what types of transmission line activities qualify for a CPCN waiver under the Public Utilities article. As OPC and other commenters and now commissioners have pointed out, the proposed COMAR revisions actually inject more uncertainty into the CPCN process for transmission lines, and it also seems to be at least somewhat an attempt to remove the Commission's authority to review transmission line projects. In OPC's perspective, staff's proposed revisions won't clarify what qualifies for a mandatory waiver because the statute establishes a waiver for construction related to an existing transmission line, and the PUA defines construction. And a tweak to COMAR's definition of modification, OPC doesn't really see how that's going to change what the PUA considers to be construction. Staff, someone acknowledged that this morning whenever Mr. Dean said, if I remember correctly, that these modification changes to what is not a modification won't bind the Commission to a finding that anything in the not modification category gets a mandatory waiver, but I'm still a bit unclear on that. Instead of clarifying what qualifies for a waiver, a change to modification in COMAR will change what types of transmission line projects require a routing analysis under COMAR if they don't qualify for a waiver. And that's something that stakeholders should discuss and consider seriously as a group, which didn't happen with respect to these proposed revisions, as has been pointed out by some of the commissioners. Also, as other commenters pointed out in their comments, staff's proposed revisions raise questions about several unclear and undefined terms that are used in the proposed revisions, as well as the status of transmission lines that were built before the requirement to receive a CPCN existed. OPC acknowledges that there may be issues and a lack of clarity about some portions of the CPCN requirements, both in the PUA and COMAR, but this set of revisions doesn't solve that problem. Like PPRP, OPC recommends that the Commission direct the stakeholders to discuss these issues collectively, whether in a work group or not, some sort of format, and make any recommended changes through a more traditional forum. Thank you, and we're available for questions.
Okay, Commissioner Linton.
Thank you, Mr. Chairman. Good morning.
Good morning.
You had a number of different comments about the regulations in your filing. And I noted earlier with the technical staff that nothing that they've done up until this point was in violation of the Administrative Procedure Act. I mean, technically, the Commission has the authority to proceed by publishing these regulations and giving all the parties the opportunity to provide whatever comments they want to. Of course, that just pushes down the line the eventual review of all those comments and potentially changes and republishing. If we decided to go back and look at this all over again, in your comments you've made a number of suggestions already, but you haven't talked about what the joint utilities proposed, which we found out this morning the staff has adopted. What are your thoughts on those?
So just like staff's proposed revisions, we didn't have time to review them in advance. They weren't provided to the parties before filing of the comments. So we've had even less time to look at those than the ones that staff submitted. We don't think that they should be published either. That they should be subject to discussion. I mean, some commissioners pointed out why is the 25% number chosen? We're not sure either. So I think those types of things would need to be fleshed out with the stakeholders before we made a decision about whether we even recommended that those be published at all.
Okay. Do you think, and this is more of a broader policy question, but do you think that that there needs to be any revision to this section of COMAR at all?
2079 specifically, or just modification?
Yeah, just the questions that were raised from 9669 and of course this rulemaking.
Sure, I think that, as Commissioner Suchman touched on, this is an area where technology moves quite quickly and things change. And at the same time, the grid is aging. So there may be other options rather than rebuild for every transmission line that is reaching its the end of its life. So I think that something that captures that reality would be something worth looking at. And if that could be included in 2079, I think that would be one option to look at. But I'm sure there's others if we met with the other stakeholders and had a time to discuss it.
Okay. All right. Thank you. Thank you, Mr. Chairman.
Commissioner McLean. Yes, sir. Commissioner Suchman.
Good morning, Mr. Miller.
Good morning.
The Commission's order in case 9669 that was issued in 2023. why do you think the commission asked staff to review the definition of modification in Comar?
Sure. So first, I don't think it had anything to do with a waiver provision. I mean, that seems clear and intuitive. But the commission did say in the part where they ordered staff or directed staff to initiate a review that given the likely need to upgrade aging transmission infrastructure within the state and in anticipation of similar CPCN filings for significant existing transmission line rebuilds, I think that kind of says it, that we're going to start addressing this a lot, and there might be new options that that exist other than just wreck and rebuild, and I think that would be something that should be looked at. I also, like you, this order, I think, predates my time at OPC or involving with the commission, but I do believe that there was a concurrent opinion written by then Commissioner, and now again Commissioner Linton, and Commissioner Richard, talking about this, but I don't have it at the top of my, on the tip of my tongue, but I do believe that that also factors into sort of what the commission was thinking when they directed staff to take a look at this.
And if we were to adopt something like the sort of staff utility proposal, how would that impact our ability to ensure that the new technologies are being deployed in an effective and efficient way?
So I believe I mentioned in the comments that modification in Comar dictates when a proposed project does or doesn't need an evaluation of alternatives, especially alternative routes. So to the extent that these modifications change what fits into the modification category, it would change the commission's ability to have the utilities propose or file and review those types of alternatives.
So it would limit our ability to do our job.
To the extent that I understand exactly what staff is trying to do.
Yeah, I was sort of having
Yeah.
similar problems. Okay, thank you. That's all I have, Mr. Chair.
So I guess my question is, do we need more authority in this area, or can we do it by changing the existing regulations
More authority with which respect, Commissioner?
regarding how to deal with modifications? And I mean, is the current statute appropriate regarding dealing with the new technologies and giving us the ability to respond quickly?
So there may be statutory changes required. My understanding is that there may be, if the commission wants to look at more than just alternative routes, but alternatives altogether, that because of 7207.9, that there would need to be perhaps a statutory change there.
Okay, all right, thank you.
Good morning, Commissioners. Sandra McLemore on behalf of the Power Plant Research Program, and we filed comments opposing the adoption of these revised regulations. And with me today is Ginny Rogers with the Power Plant Research Program to provide some comments, and we're here for any questions you may have.
Good morning, Commissioners. I'm Ginny Rogers on behalf of PPRP. Like many of the parties sitting here, we find staff's proposed changes to be somewhat confusing and somewhat conflating the terms modification and waiver. I actually was there for case 9699 and did hear the arguments that OPC made and the reply that Potomac Edison made, and it did have nothing to do with the waiver. It was more whether or not the rebuild was a modification and had to perform an alternatives analysis. And in OPC's case, it wasn't necessarily an alternative line route, but more about the non-wire alternatives and the new technology and whether that would be a better improvement rather than just straight out rebuilding the line as it was. So in that case, we didn't get too much into the details of the exact words that staff proposed because in general we do just think that there might be a better way to do this. We don't necessarily think a work group is the best way, but if it would be better than what staff proposed, it would give all the parties some time to think about this problem and to address it in a better way. As far as the waivers are concerned, it might be better to better define, I know you guys want broad authority, but it might be better to better define what a good cause waiver is versus a mandatory waiver. I've sat and listened to some of those here at admin hearings, and I think the water gets a little muddy. PPRP is also concerned that this could lead to too many waivers and sort of a skirting of the CPCN process, which takes away the Commission's authority, as you mentioned, Commissioner Suchman, and waivers, we cannot place conditions on a waiver, either discretionary or for good cause, and that means that well, the commission, through us, has no say in how the line is built and whether or not certain environmental rules are followed. And I think that's about it. I do want to point out, as far as the timing of the CPCN, I'm working on a current case right now, and it filed last summer. We filed our testimony in about 9 months with the idea that a CPCN would be received within about a year. Now, our caseload is a lot higher now. It's a little less doable, but we do try to work with each individual utility as they come in and take a look at their in-service date and try to accommodate them as best we can. Thank you.
Okay, Commissioner McLean. Commissioner Suchman.
No questions.
Commissioner Linton. Well, actually, so the last issue that you talked about, obviously we're reliant on the information that you provide to us to form the basis of the decisions we make. And you're comfortable enough with the existing authority that you can do your jobs?
Yes, as far as the mandatory waivers are concerned.
Okay.
I think there might be a chance to look at the discretionary waivers, and we cannot place conditions on them. We do come and form an opinion and provide our opinion to you, but I think in some cases there are times when we wish we could put some conditions on this.
Okay, all right, thank you. All right, so I know the Exelon folks are here. Is there somebody here from PE too? So why don't we have...
Yes.
Okay, so why don't we have all the utilities come up and we'll just go through you.
Oh, sure.
Good morning, Chair Hoover, commissioners, and special hello to our two new commissioners, because I haven't had a chance to appear before you. So, former Chief Judge, now Commissioner McLean, welcome, and Commissioner Linton, welcome back. Look forward to appearing before you going forward. I will let the other folks introduce themselves before we have our up-down comments, but my name's Daniel Herson. I'm representing Baltimore Gas and Electric Company, and I brought with me David Outen, sitting right here. He's a section engineer in our transmission planning and construction group. He's been involved in many CPCN and CPCN waiver application efforts in the past.
Good morning, Mr. Chairman and Commissioners. Matthew Seeger is appearing for Pepco and Delmarva Power, and with me is Mr. Ray Ruwalt, one of our senior engineers working on transmission lines.
Good morning, Mr. Chairman and Commissioners. Robin Leone appearing on behalf of the Potomac Edison Company.
So, Chair Hoover, Commissioners, first I want to thank staff for their analysis and their proposal. As we said in our comments, I think it was grounded in good intent. I think we heard Mr. Dean say that, they interpreted the order from a couple years ago, how they interpreted it, and they went forward and did what they thought they had to do. Our thoughts are several, and I'll walk through them. First of all, I'll acknowledge it was me on the call that Mr. Dean posted that proposed, hey, do you really even have to propose anything here? I think the request from the commission was, take a look at this. If you think there are issues that need to be addressed, then bring them to the commission. And they elected to do that, but I think our initial thought was, I don't know that this is necessary or not. I'll just tell you from our perspective, and by the way, we're both sitting here at the table. I'm speaking on behalf of both companies. If there are differences between the two, Mr. Seegers can chime in. But, I think our view on this is that the current system works. We have a full CPCN in certain situations. We have a discretionary waiver in certain situations, and we have a mandatory waiver in certain situations. And it's not perfect. We'll acknowledge that, but I think we've been able to work with that situation and that construct well over the years. So I don't think we have to have proposed changes to COMAR here. We just simply offered our changes if the commission decided they were going to go down this path and make changes to COMAR. We offered the suggested changes that we did, and I'm happy to walk through all of them or some of them and answer questions about them. But if the commission says, you know what, we don't really think we need to tinker with this, we would have no objection with that. Regarding the work group, I'm always reluctant to say I want to get involved in another work group, but we wouldn't have any objection to being part of that, and I think we should be part of it if it's going to happen. Again, we just offered the suggested changes to enhance, I'll say, staff's proposed changes, because when we read them, we had some concerns about narrowing flexibility. For example, if there was a situation where we had a project where a tower was going to be 1 foot higher than an existing tower, does that automatically mean that it's a modification, or does that automatically mean that you have to seek a full CPCN for that? We wanted to avoid those situations, so we tried to bake in some flexibility to staff's proposed changes. And the way we did that was, and we tried to be consistent throughout the different paragraphs, but our thought was there's going to be situations where we may have certain standards or certain practices that we want to adhere to in construction and design, and we would like to be able to make the case to the commission that that should not necessarily mean that it's a modification. Additionally, there may be a situation where we wanted to increase the height, but we thought, this increase in height isn't really going to be noticeable to anybody on the ground. So if it's 16% instead of 15%, automatically do we have to go seek a CPCN? We wanted to bake in a little bit more flexibility. And I know one of your questions was, where did this 25% number come from? It wasn't just pulled out of thin air. I consulted with Mr. Outen and his colleagues, and I said, okay, take a look at the proposal here, the 15%. Is that going to cover most of the instances where we have an increase in conductor size, for example? And they said it'll cover some of them, but not all of them. And I said, well, what's a number that would get you in a place where you could consider, more options? And they said, 25% would probably cover most of that. And that's not a bad thing. I don't want to suggest that the increased flexibility means that we're looking to do something that's more expensive or more complicated. It's actually to the contrary. I'm told from our engineers that if you have that added flexibility, you can consider more options for conductor size, for example, or conductor technology that perhaps would allow you to incorporate enhanced grid technologies, or you could do more with less. So to us, there is some value in having that flexibility, and that's why we put it in there. And then, we just wanted to make sure that those additions were consistent across the different paragraphs, so that's why we have really the same language in each of the paragraphs where we made some additional changes. In terms of the static wire addition, static wire is, a technology that's meant to protect the overhead transmission line. It goes on the very tip top of the structures. It helps deflect lightning or absorb lightning so that you're not damaging the transmission lines. There's a couple different types of it. There's regular shield wire. There's also shield wire where you can incorporate communications technology. That's optical ground wire, or OPGW. And there may be situations where we either want to add that to a line or we want to replace that. And again, we didn't want to go through the full CPCN process just for something like that. So we thought that was a thoughtful add if, again, we're going to do these proposed regulations. Regarding the I heard some questions about the CPCN process, and we're happy to talk through that. And by the way, I thought there were some good questions this morning and some thoughtful dialogue, and we'd like to continue that conversation here. The CPCN process has its place. It's an important process. We don't disagree with that. It allows the public to be involved through evening public hearings. It involves all the stakeholders in this room and even in many more to intervene in cases and file testimony and cross-examine witnesses and everything that comes with the CPCN process. But it's long and it's expensive and it is not necessarily efficient. And I know that when we have to do a full CPCN, we're looking at probably a year to 2 years for most projects. And that's not to cast any dispersions on PPRP. We know that they have limited staff and they have a crushing caseload of cases, but that's just the reality. So, we know, and I advise my clients that, hey, if we're going to have to get a full CPCN, we're looking at up to 2 years to get this approved potentially. And there are cases where that's necessary and appropriate. But I think there are other cases where that's really not appropriate, and do we really want to incur the several $100,000 in having to prepare an environmental review document and have to hire consultants and have to put up all kinds of witnesses and go through extended review if we're doing something that's routine repair or maintenance, or we're doing something that's rather limited in scope. And that's why I think there is value in having the waiver process, whether it be mandatory or discretionary. And we can get into the conversation about which one we prefer, or why we decide to do something we do. But I'll just tell you, when my client brings me a project, my steps that I go through to see whether we're going to do a waiver or not is I'd first say, hey, what are we talking about? A new line here? Is this new overhead, or is this something on an existing line? If they say it's existing, then we go to the PUA. I don't go to COMAR first. I go to the PUA first. I say, let's look at the provisions. Does this qualify for the mandatory waiver provision? We go through that steps. If it's not obvious that it does, then I'm basically telling them, we're either going to be seeking a discretionary waiver from the commission, and that, as Ms. Rogers pointed out, is not always clear. We've come here before with discretionary waivers, and there's really no definition of good cause. It's really at Your Honor's discretion on that. And then there are some where we'll just conclude, we're not likely to get a waiver here, so we're just going to have to go through the full CPCN process. So that's really kind of the steps I go through, when I'm advising our clients on how we approach the commission with projects. Commissioner Suchman, I think I heard you mention something along the lines earlier of, what is our intent in proposing projects? And, I'm going to respectfully push back a little bit, because I heard you say suggestions along the lines of, we're looking for projects where we can do capital projects and rate base it and earn a return on that. There are certainly situations where that's the case, but I think it's a much broader look. I think when we look at projects and potential options, we're trying to decide what is the best way at the best cost to get what we need to make sure we have a safe and reliable system that's supporting our business and supporting our customers' needs. So I don't think it's as simple as, hey, let's take a look and see what we can capitalize and earn the largest return on. It's much broader than that. And then in terms of the mandatory waiver process, I think everything on this list in the proposed regulations is informed by staff's review of past waiver applications. Now, I don't know if they were all mandatory. I think maybe there were some that were discretionary. I don't know if any of them came from full CPCN cases. But I wouldn't say that, we automatically would look at this list and say, oh, well, that's a mandatory waiver for certain, slam dunk. First of all, we're going to bring mandatory waivers before this commission unless Your Honors tell us you don't want to see them. Whether you think you have any ability to review them or not, we routinely bring them before you, because that's how we interpret that statute, that we can't just do the work. We've got to bring it it to you and get approval, even if it is a mandatory waiver. And I will also say, we're not considering alternatives, even if it's not necessarily required as part of the waiver application process. We watch all the administrative meetings. We see what's going on with most of the cases, and Mr. Seegers and I will routinely advise our clients that, hey, even if we don't have to do it, we really should think about alternatives, not only route alternatives, but technology alternatives. Because we know your honors are going to ask us questions about that. So when we're putting together a proposal, Mr. Seegers and I, we ask our clients the tough question. Hey, did you consider grid enhancing technologies here? Hey, did you consider a battery option instead of a replacement of a transmission line? Hey, did you consider a different route here, or does it make sense to go the existing route? We go through that exercise before we bring an application to your honors. So I just wanted to state that if there was any doubt about how we're approaching these cases and what we bring to the commission for consideration. So I'll stop there, ask Mr. Seegers if he has any questions, and then or statements you want to make, and then I'm happy to entertain any specific questions. Thank you for your time.
I have nothing to add, Your Honors. Mr. Hurston summed it up pretty well.
Commissioner McLean.
Good morning.
Morning.
To the regarding alternatives, Mr. Hurston, to the extent that there are some kind of regulations that actually require the company to demonstrate, hey, we looked at X, Y, and Z before we came to you with a full rebuild, for example. Is that something that BGE and PHI would oppose, or would you support it? I mean, if you're doing it already.
You mean to put into Comar?
Yes, sir.
Yeah, I mean, obviously we'd have to see it and,
right,
and
right.
have the opportunity to comment on it. But yeah, I think in concept we could get behind that.
Okay. All right.
Yeah, Your Honor, I just, in that particular case, I would just, I guess one initial concern is that I would not want the Comar language to be too prescriptive in terms of like you must look at these alternatives, just in terms of, but I don't think we would necessarily have any issues with looking at alternatives. As Mr. Hurston said, we do that now.
Sure.
So.
Yeah, and I think just some of the concern is that it's just doesn't make its way into whatever filing. And not saying that that's wrong or right, but I mean, if you're doing it, you just carry it forward. That's all. Thank
Yes.
you.
Yeah, I mean, I'll just add, we do try to put in our filings, to the extent we've done it, I think we try to put something in there about, hey, we looked at a different technology. I don't have them all in front of me.
Yeah, and I'm not saying that you don't. I just know that was an issue in the case that I had with Ms. Leone in 9669, a concern about the lack of alternatives, and I found that they weren't necessary. So, but all right, thank you.
Commissioner Suchman.
Okay, so Mr. Hurston, I usually don't respond when somebody has a concern about a statement that I made, but I just want to be clear. I don't fault the utilities for what you need to do as an investor-owned entity. My concern is our inability to actually look at what you're doing because we have a different responsibility, and if you take us out of the equation, then you could be offering the best approach, and we won't be able to weigh in, and that's my concern. Is that it's like a sort of delicate balance, and we all have different interests, and if we're taken out of the equation, that's sort of my concern. I actually think we are not unaware of the challenges of CPCN process, and it may require us to look again at different pieces of it to try to make it work better. I have the sense from the parties today that the proposals offered by staff, which I know Mr. Dean had worked very hard on it, but it may not have been reflective of perhaps what the commission had intended when they issued the order. Others on the commission issued the order, and I also am getting the sense that no one in the room is supporting what's being proposed, including the utilities. You said it yourself that the definitions that are currently in place work for you. I mean, maybe they could work better, but that you were offering modifications only because you were concerned about some additions that could have an impact on the company.
That's correct.
And so, Mr. Chairman, it just seems to me that sending it back for a work group doesn't make a whole lot of sense. Maybe sort of taking what we've heard today and the conversations that we've had today, and incorporating that into things that we might want to do in the future, perhaps even making changes to the PUA to make the process work better. I never believe that any effort is wasted effort, that there's always something to learn from the process. And so it seems to me that maybe making changes to the modification definition don't make sense right now, but it may be that other things need to happen to make the process work as best as it can, and for all of us to be able to effectively participate. I mean, we heard some comments from PPRP about things that they would like to change as well. But I'm not sure that the modification definition is the right approach at this point. So that's all I have.
Okay. Mr. Linton.
Thank you, Mr. Chairman, and good morning. Just so that I'm clear, we have all three, well, I guess all four, utilities here, Exelon Joint Utilities.
And Potomac Edison.
And Potomac Edison, okay. So I guess I'll ask the question two different ways then. For the joint Exelon Utilities, I did hear kind of a couple of different positions on what's in front of us now. You proposed some changes to the staff draft, but you also admitted to being our secret caller. So you were the person who suggested there may not need to do anything.
That's right.
So for us today, are you proposing that we published the staff draft with your changes, or are you suggesting that we do nothing?
I'm suggesting that if the commission feels that they want to propose regulations and they want to go with what staff has proposed, that we are respectfully requesting that our additions be included with that published proposed regulations. If the commission decides we're not comfortable moving forward with proposed rulemakings right now, we have no objection to that, because again, like I stated, we can work with the current system, and we believe it works fine for what we need.
Okay, and I guess to complete the menu, if we decided that you needed to discuss this further with staff and the other parties, then you'd be at least willing, I won't say comfortable, but willing to go back and participate in the work group.
Absolutely, yeah. I think we need to be part of that conversation. I think we're an important stakeholder when we're talking about regulations regarding our assets and infrastructure. So yeah, we would want to be at the table, and we would show up.
Okay. So for Potomac Edison, clearly you didn't propose the changes that the Exelon Utilities did propose. What is your position?
So, thank you, Commissioner Linton, for asking that question. I do want to sort of frame my response a little bit. I think we share a lot of the same thoughts as the Exelon Utilities with respect to things like, is this the right approach in relation to the question posed in the order in case 9669? We agree that if further discussion is necessary, Potomac Edison is also happy to be participating in a work group of some kind. With respect to our comments, they were, I think you would agree, they're more clarification seeking than they are, here are changes to wording that we would propose. That we did have one that was, suggesting that we include a specific word, the word existing, but otherwise, we did not really propose wording changes, in part, I think, because we have the history. As Commissioner McLean alluded to, I was lead counsel in case 9669 for the Potomac Edison Company, and as Ms. Rogers explained, the issue there became whether or not we needed to talk about non-wires alternatives, because it was a modification and not a new line. And then it kind of became a philosophical debate. And when does an upgrade that is a rebuild that is occurring in existing right of way and isn't requiring any additional acquisition, when does it ever cross over into new line territory? And that was the issue that we struggled with in that case. So I think for us, these proposals, it's certainly something that we wanted to be participating in because, we are one of the investor-owned utilities, and these conditions will apply to us regardless of how they evolved. But I think for us, it didn't come from the place of where we saw the initial problem. So our comments were more, advisory and not so much here are wording changes that we would like to see. And with respect to the changes that the Exelon utilities have proposed, I have not had a conversation with my client about whether or not there are any issues with those. So that would be something that we would want an opportunity to sort of re-comment on. If those are going to become the commission's proposal, we would want to be a part of being able to comment on that second draft, if you will.
Okay, so I noticed you left out the work group part. I won't say anything about that. So there has been some conversation here today about the CPCN process as a whole. And at least for myself, I've asked the question and wondered aloud about whether or not there's been some, whether utility companies have chosen to pursue the waiver approach as opposed to the CPCN, if given the option to pick one versus the other. I think for at least for now, at least, that's probably a conversation for another day. But I appreciate the opportunity for being able to say it, and I at least want to give you a chance to respond to it, since I did mention that I would ask you the question about it.
I would say there's probably not an absolute answer one way or the other. Yeah, we've had a lot of cases over the years. If it's something that can fit into the mandatory waiver, I will acknowledge that it's a great likelihood we will probably propose or request a mandatory waiver. That's why the statute's there in our view. It has value and it has purpose. If it's not clear, and I'm looking at a discretionary waiver versus a full CPCN, I'll be honest with you, it's really kind of case specific. Again, because we don't really know what good cause necessarily means. Although Commissioner Linton, I famously quote you from a couple years ago. I think you said something along the lines of, it's not good cause just because you need it. There has to be some reason why we should give you this waiver if it's not fully compliant with the mandatory statute, for example. That uncertainty may lead us in some instances to say, let's pursue the full CPCN. We know what that process is. We know what it entails. Let's go down that route because the other route is maybe not as certain. Now, if my client says something like, well, let's try to get a discretionary waiver, and if we don't, we can pursue the CPCN. Maybe we take that route. But again, that's going to depend on a couple variables. When do we need the transmission line in operation? When do we have to take outage windows? When is PJM, for example, directing us to have something in operation if it's a PJM directed project? Do we have the ability to wait several months to have a discretionary waiver put on the admin calendar, heard at the admin, and then decided on? And then if we don't get it, are we behind the 8 ball then on a CPCN? Maybe we can't afford to lose that 2 or 3 months. So we'll just go ahead and file the full CPCN. So it's a little hard for me to say with certainty in answer to your question, hey, we're always going to do this, or yeah, I remember 5 cases where we actively wanted to avoid a CPCN, so we crafted it to fit under the waiver provision. But I will acknowledge that there have probably been cases where we've said, hey, what can we do to avoid the full CPCN process? Because not because we don't want input from the public but because we don't really think it's the kind of case that warrants or lends itself to the CPCN process, and we don't want to incur that extra expense for our customers. We don't want to have to put the administrative burden on ourselves and the commission and the stakeholders. So, we'll try to pursue a CPCN alternative.
And Commissioner Linton, just to add on to that, I can say that from my recent experience, whenever we're rebuilding a line, for example, if we have to address a PJM violation, in fact, all of the cases that I'm aware of, we're dealing with a line that has been there for a number of decades. That in every case that I'm aware of, was around, and I don't believe they ever had a CPCN, so it never went through the CPCN process. And so if we are rebuilding a line in those circumstances, then, in my estimation, I always tell them we need to go through a CPCN because that's what the commission would want, that's what the PPRP would want, I believe that's what OPC would want. So that is an additional consideration, is if we're talking about that versus if we're building a new substation and we have to reroute an existing line into that substation by just installing a couple of structures to get that rerouting done. That is very different, and I think that in those cases we would come in for a waiver, either a mandatory or discretionary. But if we're talking about the former, then in my view, I always tell my client that we need to go in for a CPCN for if we're rebuilding an existing line that has been there since the 1970s or 80s.
I mean, I would agree with that. That's exactly the situation in 9669. That line, I think, was there in the 60s. So it was never a question it just wasn't going to be some kind of project that could potentially be subject to a waiver. It just didn't even cross our minds, I don't think. We immediately were thinking CPCN. For us, a waiver is something like, adding a couple of poles, especially if we don't have to do it on other property. We can do it on Potomac Edison property. That's something that is sort of in our minds, well, that's a waiver type of project. Certainly you're going to have projects that just kind of don't fit in either one of those, and then it becomes a question of how we're going to do it, and then that's something that happens internally with legal staff at the company as well, and we try to figure out what makes the most sense. But definitely to the point earlier about losing time, we don't necessarily want to be in a situation where it's a gray area and we're deciding, well, let's try the waiver first. That just is not sustainable in most cases. I mean, we probably would just say CPCN just to be on the safe side. So I don't know if that's helpful or not, but I think we are experiencing a lot of the same things when we are looking at the wording of the statute in particular when it comes to a modification. It's not so much the regulations.
Okay. I know that's very helpful. I do appreciate it. And that's actually all the questions that I have. So thank you, Mr. Chairman. Thank you for answering my questions.
Okay, so on the 25% number, you said you talked to your engineer folks and their attitude was that 25% was the appropriate number. Historically, has most of the situations that you've dealt with come under this 25% number, or is it somewhere between 15 and 20?
Yeah, I think it's, well, I know the 15% was one of our cases.
Mhm.
So certainly we've had that experience before. Mr. Out, do you have any thoughts? Yeah. I don't know if we've. Yeah. Okay. Yeah. I mean, Mr. Outen, in preparation for this, he had sort of done an analysis of, hey, if we go with the 15% versus the 25%, where are most of our cases and technologies going to land? And we determined that sweet spot was somewhere between 15 and 25. So we went with the 25 for a couple reasons. One, we figured that was a number that could get us where we needed to be most of the time, and we also thought, hey, there's going to be at some point where the increase in either the tower height or the conductor size diameter is going to be noticeable to folks on the ground. And we didn't think there was an appreciable difference between the 15% and the 25%. I guess reasonable minds could differ. But we thought that was probably, the appropriate value to pick.
Okay.
If the commission, wanted to go somewhere in between, I don't think we would have a strong
All right.
objection.
It wasn't my intent to ignore Potomac Edison when I started with the Exelon folks. So I know you've given a lot of responses in response to the questions, but if there's anything else that you specifically want to say, go ahead. So.
Mr. Chairman, it's totally fine. I did, sort of try to frame when I was first responding to Commissioner Linton. So the commission obviously has any other questions for.
Yeah, I was going to say, anybody have any
Happy to answer.
questions for her? Okay. All right.
I had one more.
Oh.
point. I can't recall if Mr. Dean went through in the very first part of the regulations, they're proposing adding a numerette to the definition of modification. And we do not support that addition.
Right.
We actually.
That's what you, I
deleted
saw
it.
your red
Yes.
strikeout of that,
Yeah,
so to
and
speak.
I don't really know that there was any discussion about that, and I wanted to just kind of give our thoughts on that.
Oh,
if
all right,
you'll
okay.
indulge me for a minute. So, the definition of modification in the regulations is verbatim the same as the language in the mandatory waiver statute right now. I know it reads a little strange because the waiver statute says if the commission finds that the projects do not do the following things, then they shall grant a waiver. And those do nots line up verbatim with what is a modification in the current regulations. I think that's important to maintain that consistency there, because if you start expanding that, what is a modification beyond what's in the waiver statute in the PUA, you don't have that congruency anymore. And I just did a little research on the history of this. The definition of modification in COMAR was actually there before the waiver statute was enacted into law in the PUA. That happened in 2012, I think, in a regular session, because BGE was having issues. We had gone to the commission several times and asked for, I think it was a waiver of the regulations from the commission, because at the time there was no waiver statute in PUA. So we asked the commission to exercise their authority to waive their own regulations with respect to minor work that we thought we didn't really want to get a CPCM for. That worked for some time, but then at some point the commission said we can't really do this anymore because the statute that defines construction kind of defines what we can do here, and we can't really waive the requirement to get the CPCM. So that's when we approached the General Assembly, and the commission supported it as well to get the waiver statutes put in place. And at the time, it was meant to track that language in modification. So I just want to give that little history because I think it's important to maintain that consistency. The other thing, real quick, is, in our view, there may be some exceptions, but in our view, the definition of construction, the definition of modification, really the whole intent of the CPCM process involves physical activity being done to an existing transmission line. What we're talking about here with this addition from staff involves no physical activity. It literally involves, hey, we're going to turn up the operating voltage of an existing line. You're not going to see any workers out there doing anything. It's just something that we do with buttons and levers. So there, when you're not actually looking at any physical activity or change being made to the line, it just really didn't make sense for us to include that in the definition of modification, which again, historically has been about somebody out there making changes to this line that are going to impact what people see, are going to impact the environment. Now, I think staff makes the argument that, well, it could impact the grid stability or reliability if you change the voltage on that. Our response to that is, in most cases, that's already been considered when the line was designed, whether it was done with or without a CPCN. A line was designed for a particular voltage capacity. If we're operating it at less than that, we've already considered any impact on grid stability or reliability, and so has PJM and PPRP if they're doing if we're doing a full CPCM, that if we're operating it at less than that capacity, increasing it so long as we're not going above that capacity number is not going to impact in a negative way, the stability or reliability of the grid. I know that's a lot. I just wanted to point out why we're advocating for that deletion.
All right, so any questions on
Can I just
that?
follow up?
No.
Mr. Herson, you said in most cases.
Yeah.
Not all cases?
Well, I said most cases because there's going to be, like Mr. Seeger said, there's probably going to be some instances where we didn't have a line that went through the CPCN process. So in that case, maybe it wasn't looked at by PPRP, for example, when they do their look at, hey, are we impacting reliability or stability? However, I think it would be looked at, if, for example, this is a PJM-driven project, they're going to look at that before they tell us to go do it, because that's part of their process. So I can't tell you, Commissioner McLean, any particular instance where that wouldn't be looked at, but I just wanted to say most because, again, it wouldn't have necessarily always gone through a CPCN.
Anybody else? Okay. All right, so let me give staff a chance to respond to whatever you've heard from the governmental parties and the utilities, if you want to. It's up to you.
Regarding the last discussion here on removing the voltage, we did note that I probably didn't spend enough time to make an impression that we were agreeing with the deletion.
Oh, okay.
I see.
Well, okay. Thank you.
Once again, regarding discussions about whether we should have a work group, if we're not considering changes to the definition of modification, we shouldn't have a work group, because that work groups really take a lot of effort. It may not seem like it, but it's a lot of time, and there's a lot of utilities. Their time is as valuable as ours. Staff didn't set out to just propose regulations to modify this. We thought we were following the direction of the commission when the commission discussed the need for upgrading the grid, or the transmission system in general. And one of the issues that we thought was a concern was reconductoring with advanced conductors and upgrading the capacity of the current conductors. Currently, if you increase the size of a conductor, and as part of the work, you're also increasing the height of a transmission structure, you can't, you're not assured of getting a waiver. It looks like it violates the text of the statute, so that's sort of an impediment for considering changes to conductor size. And I don't know if the utilities feel the same way, but it just seemed directly a limitation on doing that outside of a full CPCN just for doing that. And I think that's all I have to say.
Okay. Any questions? Okay, so we will be issuing something as to whether or not we're going to take any action on this, and we'll issue order or notice forthwith. So with that, we're adjourned.
Thank you.